Hello again, everybody. My name is Tom Reilly. I am the chair of the Business Services Group at Gross McGinley, and with me is one of our business services attorney, Jessica Kaczinski. Jessie practices in the Business Services Group but specializes in business litigation. And I say that for a reason, because there's a reason Jessie's here today. Number one, she's very good at analyzing new laws and determining how we make them work for our clients. And secondly, she's very good in defending our positions on those laws if in fact we take a position that someone else disagrees with and our clients are challenged. Earlier this week, Jessie was successful in winning a case that I told her she was going to lose. Both she and I were very proud of that result. And I've not been in a courtroom in 20 years, something I'm very proud of. What makes our business services group here at Gross McGinley so dynamic and so able to address clients' needs is we bring in disciplines from all areas. People like me that deal strictly with the transactional side of business relationships and business clients, and attorneys like Jessie that focus on that piece, but also focus on what happens when there are issues, when mediation, when discussions, when trying to find a solution that works for everyone doesn't work, and you need to actually sit down and arbitrate or litigate a case. Well, this is the second time this year we've gotten together to discuss with you the federal government's intrusion into areas of law that have traditionally been governed by the states. Earlier this year, we told you about the Corporate Transparency Act and the need for every corporate entity, limited liability company, corporation, business entity, to file with the federal government for existing entities prior to year end. If you haven't watched our vlog or read our blog about that, I suggest you do so, because in addition to what we're sharing with you today, that is very important new information, something you're going to need to address by year end that you've never addressed previously, much like what we're going to talk about today. Getting back to why we're here today, we're talking about the recent ruling that came out from the Federal Trade Commission, an agency of the federal government, where it is attempting to ban non-competition agreements in the employment context. A little bit of background, much like with the Corporate Transparency Act, corporate law, business law has always been the domain of the states. Every state has some guidelines or rules or laws governing non-competition agreements. Not surprisingly, they differ from state to state. Some states, I believe there's a total of 6, most notably California, don't permit non-competition agreements at all. Other states like Pennsylvania have actually been very employer-friendly over the year and permit reasonable limitations on future competition by employees of a company. Pennsylvania is actually more on the side of being employer-friendly than many other states. Again, 50 different states, 50 different interpretations of whether non-competition agreements are legal, illegal, enforceable, non-enforceable. Until now, where an agency of the federal government is trying to say non-competition agreements are prohibited throughout the entire United States, period. Before we get into the discussion we're going to have with Jessie today, let me just step back a second and explain to you what a non-competition agreement is. While you likely know, it's probably important that you sit down and analyze the 3 component pieces of a well-drafted non-competition agreement. This is important because, as we're going to discuss today, really only one of those 3 pieces is being eliminated by the FTC. The first is a covenant against not competing, where an employee agrees that as a condition of taking a job or getting a promotion with an employer, that employee will not, while employed for that employer and for some period of time afterward, compete in the same business, the business that the employer is in. The second covenant, often in the same agreement, is a non-solicitation covenant. The employee agrees, that while it's employed by the employer and for a period of time after that employment ends, it will not solicit any of the customers of the employer. It can compete head on in the business, it just can't call on its former employer's customers for some period of time. The same normally holds true with employees, where an employee agrees it won't solicit for employment people that worked or are working for the former employer. And the last piece is a prohibition against using any of the company's proprietary information, confidential information, or trade secrets. Those 3 components make up what I consider to be a well-drafted, well-crafted employment and non-competition agreement. Jessie, why don't you talk a little bit about what the FTC has done, when it goes into effect, and what it means to non-competition agreements across the United States.
So the FTC, the Federal Trade Commission, recently, April 23rd, issued its final rule which bans non-compete, which is only one part of the three parts Tom just described. The first part, the working against the business directly for during or after, for a period after, in the employment context. That's going to apply to employees and independent contractors. It is likely going to take effect by September 4th. The way its effective date is, it's 120 days after it's published in the Federal Register, which is currently estimated to happen in early May. So these agreements, the FTC now is banning all non-competes for any existing or new employees or independent contractors unless they are deemed senior executives.
I want you to focus a little bit on the very limited, very grandfathered or grandmothered, however you want to describe it, piece of senior executives that will still be bound by a non-competition agreement.
Yep. So only senior executives who are currently employed with an employer will be exempt from this new rule by the FTC. But the senior executive has to have a salary of at least $151,000 in the preceding year and must have policy-making power, which is quite narrowly defined by the FTC to basically be any C-level officer or high individuals within a company.
And what happens when the company hires a new, you said that the current senior executives are exempt. What happens when I hire a new CEO or a new CFO for my company? Can they still be bound by a non-competition agreement?
No, they are not going to be. It is only grandfathering in existing senior executives. Anyone hired from the effective date on, which is currently estimated to be September 4th, will not be able to be subject to a non-compete agreement, whether they're a senior executive or any other employee.
I know the FTC's intended ruling and intended ban is chilling to the business community, but another piece that I'm hearing business owners are concerned about is, does this apply when I sell my company? When I sell my company or when I buy a new company, can I know that the person I'm buying the company from, can that person be bound by a non-compete?
Yeah. So originally, the FTC's proposed ruling did touch on that. However, the final rule, which will be the one that goes into effect, will allow non-competes to stand for the sales of business entities as long as they're deemed bona fide sales, which would be any sale for an arm's length negotiation for compensation.
So the ban only applies in the employment context, not a non-compete in the context of a sale of a business.
Correct. Yep. It is only going to apply in the employment context, but just going to apply to employees and independent contractors or any other type of employment position.
Let's shift a little bit and talk about non-solicitation covenants. Mm-hmm. Again, sometimes a separate agreement, but usually a part of the document that's called the non-compete agreement. Can I, as an employer, still enforce those non-solicitation covenants against my current employees, and can I require new employees to sign non-solicitation agreements?
Yep, so non-solicitations are going to be able to remain as long as they're only touching on the solicitation of clients or employees of the employer. If it starts to get a little murky with non-competes, you might have some issues as to how the FTC ruling applies.
And what about my proprietary information, my trade secrets? Can I still enforce those provisions against current employees? And can I require new employees to sign agreements indicating they will not disclose or use that confidential information other than on behalf of me as the business owner?
Yep. So your confidentiality and proprietary information covenants are going to remain in full force as well.
We're recording this early May. Summer is approaching rapidly. You heard Jesse say earlier that September 4th, I believe,
September 4th
is the date when this regulation is likely to go into full force and effect. I tell you that because if you're watching this later in the summer, or if you're watching a Labor Day weekend, you've got a lot of work to do before September 4th. What are employers required to do with regard to existing non-competition agreements that they have in place with their employees?
Yep. So any existing non-compete that's in place with employees, aside from the senior executives who will be exempt from this new rule, the employer is going to have to give them notice that they can no longer and will no longer enforce the non-compete. The FTC has provided model language, however, we would suggest tweaking that a little bit to include that the non-solicitation and confidentiality provisions of any existing non-competes are still enforceable and will still be enforced.
And an important point to remember there is what we're talking about now is very general concepts. You and/or we really need to read your non-competition agreement to tell you exactly what covenants exist. Not every non-competition agreement is identical. Some don't have non-solicitation provisions. Some may not have proprietary information provisions in. So what you need to do is determine what agreements are deemed quote-unquote non-competition agreements for purposes of this new FTC Act. Determine what rights you'll still be able to enforce in those agreements, and in a very nice, but I suggest straightforward way, make it clear to your existing employees that while you will no longer be enforcing your non-competition covenant against them, you fully intend to hold them to the non-solicitation covenant and the proprietary information covenant, and maybe it may be the perfect time for you to remind them exactly what they agreed to when they entered into those transactions. One other thing, Jesse, I think we should touch on before we get back and revisit the notice thing one more time, is one of the basic tenets of a non-competition agreement, which is really a covenant, a promise to not do something in the future. You need to receive something in consideration for that. So if you signed a non-competition agreement in conjunction with taking a position prior to the FTC, that was enforceable. If you signed it after you went to work for the company, but in exchange for a promotion or an increase in salary, that is enforceable. If they simply walked up one day, your employer walked up to you and said, here, sign this, and you did, it's an unenforceable agreement. Why? There was no consideration for your promise, your covenant, not to compete. So one thing you cannot do as an employer, you can't go up to your existing employees on September 4th and say, our old agreement isn't enforceable, here's a new agreement I want you to sign that covers non-solicitation and confidential information. Why? Because you didn't give them anything of value, of consideration for that. You can do that in conjunction with annual raises. You can do that in conjunction with promotions going forward, but the same rules that applied to the original agreement apply to you. You're correcting or fixing defects in that agreement now that the non-competition clause or covenant is lost. So we suggest you approach that very carefully. We suggest you consult legal counsel, hopefully Gross McGinley, and we can walk you through that. We can also walk you through what your agreements say and craft your notice in a way that meets the FTC requirements, but also makes it clear that you fully intend to pursue the other covenants, the covenant of non-solicitation, the covenant of non-competition, that are a part of many, well, part of all well-crafted non-competition agreements. So Jesse, I've heard that there has been some challenges already to the ability of the FTC to even enforce this rule. Can you tell us a little bit about that and where those various challenges stand and what may or may not happen over the summer?
Yep. So the U.S. Chamber of Commerce has filed a challenge in the Eastern District of Texas, and another business type organization has filed one in the Northern District of Texas. These are both two federal lawsuits that have brought preliminary injunctions as part of them, meaning that the judge will look first to the preliminary injunction and rule on that, and that can put a pause on this FTC ruling until the full lawsuit goes into effect.
So if the judge rules that it is more likely than not that the FTC is not able to do what it's trying to do, the judge can say, whoa, don't begin to enforce this FTC until after the trial when the case takes place.
Yep, that's exactly how a preliminary injunction works. However, it kind of gets a little muddy then as to who that pause applies to, whether it applies just to the members of the U.S. Chamber of Commerce or everyone, and how that goes to the rest of the United States other than just the Northern District or Eastern District of Texas. But that's currently calendared to be about mid-June when that preliminary injunction will be ruled on.
So I think the takeaway here today is twofold. Number one, no matter when you're viewing this vlog, it's not too early to begin reviewing, first of all gathering, because you may not know where they all are, and reviewing all of your non-competition agreements to determine exactly what rights your employees have vis-a-vis the non-competition clause not being enforced, as well as what rights you may continue to have regarding non-solicitation and proprietary information. The second piece is stay on top of what's going on with the litigation. If there's an injunction that applies nationally, then this entire matter will sit for probably several years. If it applies to just small pockets throughout the United States, you as an employer in Pennsylvania will very likely need to comply with this by September 4th. So lots happening between now and Labor Day, lots happening after Labor Day before the end of the year. We hope that you stop back here and see what we have to say, and we'll bring you up to date as things happen regarding this issue, as well as the Corporate Transparency Act. And as always, we thank you for your time this time. Until next time, I'm Tom Reilly.